morning, everybody, and welcome to May's coffee break briefing. As we said before, been done in a slightly different way today, just because of some technical issues with the platform we usually use. So thank you all for switching over to Teams so quickly so that we could make a start. Today's session is part 2 of the Employment Tribunal series of these, which I thought I would run through, building up for those of you who have already seen the notification and are maybe already signed up for it, to the mock tribunal event that we are doing in the middle of next month. I'm joined again by Nathan Andrews, our new head of HR services. I say new, he's been with us nearly a year now.
Gathering dust slightly.
So I think I'm going to have to stop saying that soon. Nathan's with me today to give a slightly different perspective on the Employment Tribunal. Of course, I can talk about it as a lawyer, as an advocate, as a representative. Nathan's had the advantage, as some of you will have done, of being there, of experiencing tribunal as a witness, of being on the receiving end of claim forms of cross-examination and people just as evil as me asking him difficult questions. So how we'll run through today, as I say, there would have been a presentation. I'm not even going to try and share that at the moment. Please do sort of chip in with questions and things as always as we go. But the structure for today is the Employment Tribunal from claim to hearing. So we'll look a little bit from me at rules, procedures, process, how the tribunal works, issuing and responding to claims as they come in, the role of case management in the Employment Tribunal, and we'll have a good conversation towards the end, I think, about what final hearings look like and what it means to be a witness in the Employment Tribunal and what you can expect in that situation for those of you who have not yet had the pleasure. So I thought I'd start by touching a little bit on process and procedure. Today's session will be a little bit more technical at some stages than it was maybe last month, which of course was more of an intro to the Employment Tribunal. So the Employment Tribunal, let's not forget, it is a court. It is governed by regulations, by statute, and primarily by the 2013 regulations, the Employment Tribunal rules of procedure. They do govern how the tribunal operates, what its powers are, and it is from that that we get many of the things that I was talking about last month, its jurisdiction, the scope of its powers, and all those sorts of things. The Employment Tribunal is subject, as are most of the civil courts, to what is known as the overriding objective. And the principle in the Employment Tribunal, perhaps contradictory to most of our personal experience of it, is to deal with claims fairly, proportionately, and in a way which avoids unnecessary formality and delay. So as I say, they are intended to be a slightly less formal jurisdiction than perhaps the other civil courts, and we'll touch on that to a greater or lesser extent a little bit later in this session. But what that means is that every issue the tribunal deals with, whether that is the final hearing establishing the actual outcome of the case, or whether it's the way it conducts itself in its case management processes, is supposed to be fair, proportionate, and avoiding unnecessary formality and delay. So those things do crop up a lot in preliminary hearings and written applications as you go through the process. What this also means is that, unlike a lot of other jurisdictions, there is a focus on early case management in the Employment Tribunal. And what you'll find is what we often call front-loading of directions. And all this means, in a very simple sense, and I suspect somewhat cynically, it's become a lot easier, given how long it takes to get to final hearing these days, is when that process and procedure is all being implemented by the judge at usually preliminary hearing stage. A lot of the process that happens in the background, a lot of the preparation is done very, very early on. So you might find you have a hearing that is listed for November 2026, and most of your preparation, up to and potentially including witness statement exchange, could well be done by sort of Easter or early summer. And again, that's quite deliberate. It's designed to encourage this early preparation stage. And in theory, early settlement. The entire civil system in the UK is geared towards encouraging settlement where possible. And what that also means is, compared to the civil courts, there is significantly more flexibility in case management. And that ties into kind of the reduced formality that you see in the Employment Tribunal. You miss a deadline in the civil courts, there will be cost implications. You will get told off by a judge. There's a very good chance the document that isn't prepared by the 25th of June will not be considered at final hearing. those of us who've been there will know that's a very, very different experience in the employment tribunal. And it's not unusual for parties to turn up with documents on the day that may not have been seen before, and for those documents to be considered and taken into account in evidence. The other thing to bear in mind with the Employment Tribunal, there is an increasing shift towards electronic filing and correspondence now. It's been the case for a very long time that we've been able to do email exchange with the Tribunal, and in that regard, to some extent, the Tribunal was actually a forerunner. We have been a little bit slower to adopt e-filing and making use of Court and Tribunal Service portal systems, but particularly for respondents now, and particularly for respondents who are represented by legal advisors, as of the end of this month, it will start to become mandatory to use the online portal system. Those of you who still act yourselves internally, who follow your own three, which I'm onto in a moment, you can still continue to use the old login system or to file in paper version or through other formats. But for those of you who are instructing us to deal with it, it will increasingly start to be done now through the portal system, finally catching up with the rest of the civil jurisdiction. So that's the boring bit out of the way. Let's talk about what happens when a claim is issued by usually an ex-employee, of course. Again, slight difference from the civil court system. The Employment Tribunal has a much more relaxed approach to pre-action steps. So those of you who are used to things like debt recovery, to use a nice simple example, will know that there is a process by which there has to be a pre-action letter setting out the nature of the debt, why it's owed, and the basis on which it should be repaid before a claim can be issued in the civil courts. Strictly speaking, that is not the case in the Employment Tribunal. You will presumably factually be aware of the circumstances because this is somebody who has been in your business every day. But there is no requirement, for example, for the employee to, as I say in the next slide, engage with ACAS. They simply have to notify them. And there's no requirement to put the complaint to you in writing necessarily before they can issue a claim. To use potentially a good example here, a discrimination claim can be issued while an employee is still employed. They don't have to have raised a grievance about it. That might be a challenge later as to how seriously they were taking it, but it won't bar them from bringing the claim. The only formal pre-action step is notifying ACAS of the potential claim. I've talked about ACAS and the role of ACAS and early conciliation in previous sessions, so I won't go over it in a huge amount of detail today, but there is absolutely no duty on the employee to engage in that early conciliation process, or indeed for you to do so. Equally, there's no particular detriment either way. Sometimes making use of that 6-week period can be quite useful. It can encourage early settlement, of course it can. But there is limited scope to do anything about unreasonable efforts to settle or anything like that. The tribunal doesn't look at that in the same way the civil courts do. As we know, there are very strict time limits for an employee to bring a claim in the Employment Tribunal, and they are short compared to other jurisdictions. Contract claim limitation period is 6 years. We know that for the majority of employment claims at the moment, it is 3 months less a day, as amended by the ACAS early conciliation period. Big red flag health warning at this point, of course, the Employment Rights Bill, very likely to become the Employment Rights Act 2025, is likely at some point in the next 12 to 18 months to extend that 3-month limitation period to 6 months for almost all claims. I say almost all because the current draft seems to have accidentally omitted breach of contract claims. I strongly suspect that's a mistake on the drafter's part and will be corrected. So I think you can assume at some point in the next year to 18 months, we are going to get a regulation of some kind which changes that limitation period. Very likely the translation will simply be 6 months less a day, again, as amended by the ACAS conciliation period. Now, what this realistically means is that when a claim is issued or even contemplated, an employee is going to have potentially those 6 months to issue it, plus the 6 weeks ACAS period. This is obviously now bringing us into the 7-8 month period. Given the increased number of claims and the limits on the tribunal process and system itself, there is every chance that you're not going to get a claim form for almost a year after the event. It's already bad enough, and no doubt all that will do is continue to cause further delays in the tribunal system. That said, once a claim is issued by an employee, they do all go through a vetting process. I know that might be surprising news to some people in the nature of some claims we've received, but they do go through a vetting process, and the tribunal can act on its own back to, for example, point out to a claimant that they don't have the length of service for an unfair dismissal claim. Unlike other jurisdictions, again, those of you who have been involved in tribunal claims will know this, a claim form is served by the tribunal itself once that process has happened. The employee doesn't have to send a copy to you directly as the employer. So that is all the background to the boring kind of procedure and how issuing a claim works. Let's move on to the bit that most people are actually concerned about, and what happens when you receive a claim. So this is now where I'm going to pass to Nathan a little bit to an extent here. I've obviously received claim forms as a lawyer. I've been sent them by clients who I'm acting for. Some of you will be on the call and will have had employment tribunal claims with me. And one of the first things you, in theory, will have done, although not always the case, is sent me a copy of this moment it's received. These are always headed in big, bold, clear text, notice of a claim. They will state the name of the parties, and they will say that name of claimant has issued a tribunal claim against you. Got a query as to whether there's slides. There aren't any at the moment. On top of the technical issues, I just didn't have an opportunity to work out the easiest way to share them. We'll send them afterwards, and we'll make sure that you've got a copy of what I've produced here, so that you've got them in front of you. So on subject of receiving a claim then, well, Nathan, you've kind of had one come in a way that I haven't before. You've been the person who's unexpectedly, I suppose, had one land on your desk. What's that like? How do you deal with it?
Well, I mean, drawing on, I've got simple experiences, but I'm afraid the experience most relevant here would be when I was in-house HR manager, and we handled an employment matter with an employee that resulted in that employee leaving the business. And that resulted in us receiving an ET1 that landed on my desk. And obviously, as an in-house standalone HR manager at that time, you know, there are all sorts of feelings that kind of come up when you receive that that initial claim. Obviously, you start to question the process you followed. You look at the claim, you try and understand what the issues are that are being raised. And it's quite easy in that scenario, particularly if you are in a standalone role, to kind of feel a level of anxiety. And so one of the main things that I certainly have advised clients over the last 10 years when I have been in a consulting role is, you know, don't panic. You know, take the time to review the claim form. Always get independent legal advice from your legal advisor at the earliest opportunity. I think that is the most imperative aspect of handling a claim, because you want to get that legal input, that legal oversight around what you do next. Obviously, you are going to have to respond to that claim in the form of an ET3 at some stage, and you want to really work with your legal advisors in preparing that response. And obviously, once you have got over the initial kind of, okay, we've got a claim, we've got to deal with it, there is going to be an aspect, certainly if you're an in-house HR practitioner, where you're going to have to start gathering relevant information that you're going to want to share with your legal advisor. So, for example, if you followed, you know, you've had an investigation, a disciplinary procedure that's resulted in someone leaving your business, you're going to want to gather and collate all of that documentation and share that with your legal advisor. And you're also going to want to look at the bigger picture around what evidence is likely going to be needed to help you present your response to that claim. So there is an element of, you know, you might have a particular process that you followed. There might be wider issues that are introduced by the claimant in the claim form that you would then realise, actually, I'm going to need to meet with, you know, members of my management team. I'm going to need to look for contemporaneous records of meetings, you know, any emails you've sent to a particular individual. All of that information needs to be gathered, and that's quite a big piece of work, depending on the nature of the claim. So my advice is, no, I'm sure your day is, yeah, don't panic. Be really clear on your timelines for providing a response. Obviously, you'll be working with your legal advisor, ideally, and they'll help shape that for you. But you should diarise key dates in terms of providing a response. If you agree dates for submitting documentation to your legal advisor, again, diarise those, get yourself really organised so you can make sure that when you need to provide that response and submit your ET3, that you are doing that on time, and your legal advisors have all the relevant information to be able to do that process justice. So that's largely it for me. It sounds a bit like it's an overwhelming process, but actually there is a process to follow, and if you work with a really good legal advisor, they will set out that process for you, and you can then use that as a checklist, which is kind of largely what I've always done from an in-house perspective.
Yeah, and I think those top two are there, aren't they? Don't panic. The natural thing to do is, I've got a claim form, I'm being taken, especially as a small organisation.
Absolutely.
So I think don't panic is the important one. There's always a way to deal with what's there and in front of you, even if maybe it is something that's been sat on until this point. We know that happens. Diarise key data. Yeah, of course, that's the interaction with whoever may be advising you. Naturally, it's also the big one is don't miss the deadline for the response. We talk about the employee having a relatively short period. It's actually even shorter for you to file your response. It's a month from the date of receipt of the claim form. The date will be stated on the front of that notice. There will be information in there about how you have to respond and the process by which you respond. And of course, you will have a copy of the claimant's claim form in there as well. You are inevitably going to be reading things that A, have probably been deliberately drafted in a way to make it sound as awful as possible, and B, may well be very personal about you or people you work with closely. It is natural in drafting a claim form to sort of make people out to be the worst they've ever been and could possibly be. So absolutely, that's not unusual at all. And yeah, I can see in the chat completely panicked when I opened the post and saw the claim. That is absolutely an inevitable thing to do for precisely the reasons we're saying. It's a deliberately provocative piece of paper, that notice of claim. It's designed to make you stand up and respond. As Nathan says, the most sensible thing you can do is read through it, make some sense of it yourself, work out what is actually being said there, what may actually have gone wrong or not, as the case may be, and then take the advice on how you address it. There's always ways of dealing with the claim when it comes in.
Just to touch on that point around it, it can stir up so many emotions when you receive that 81 and you see what's written. I know from my own experience, and the one that I was just talking about, where I was an in-house HR manager, I was in a standalone role. I was a member of the senior management team, so we had almost conflicting hats. And when you see that you have been cited in that 81, that you are being challenged or criticised about a particular process you followed, it is very easy to take that personally. And actually, the best bit of advice that I was given, and the advice I give now, is you need to remove the emotion from it. You just need to look at it from a factual perspective. It's really, one of the benefits of actually accessing great legal advice early on is that a good lawyer will help you to detach yourself from that kind of emotional response, and for you to look at things on a more balanced perspective. Like, okay, let's just look at this from a process perspective. Because largely, as an HR practitioner, our involvement in matters that are brought about that claim would have been process and procedure internally. So it's really good practice just to step back and go, okay, I need to be able to help my legal advisor understand the process that I followed, how do we arrive at certain conclusions, and what information and evidence do we have that supports that decision-making process. And once you can start sharing that information with someone like Chris, for example, you can then start getting proper advice about what you do next. And obviously you can't avoid having to go through that process of gathering information, and yes, it can be time consuming, but once you get that legal advice and you've got a framework around what you need to do next, it does help you to reassure yourself, and also put to one side that kind of the anxiety around it.
So yes, try not to panic. You inevitably will, and that's absolutely fine and understandable, especially if it's your first time receiving one, or as Nathan says, if your name's in it. So procedurally, certainly from a legal point of view, then the response does have to be done in the ET3. There's absolutely no question about that. That's part of the procedure rules. You can't just write an email to the tribunal, as I've known clients try to do before. As I said earlier, that is now almost entirely done online. If you're doing it yourself, if somebody's in-house preparing that response for you, you can still use the existing online system. Legal representatives, as I said earlier, towards the end of this month, I think it's about a week's time actually, will have to start using the online portal for filing responses. The deadline I mentioned, it's 28 days from receipt of the claim form. It will be stated in the notice when the tribunal has to receive that claim form, and it's by close of play on that day that's stated. There is the scope to make applications to extend that date, and there are all sorts of reasons why you may wish to do that. The tribunal is, generally speaking, slightly more relaxed about allowing respondents a bit of scope to file a response than they are about claimants being late. The simple reason is the tribunal itself recognises that 4 weeks is a very short amount of time to go through the entirety of a claim form, collate information. People may be on leave, people may be on holiday, people may be doing more urgent business stuff. All of these are potentially justifiable reasons. And there are 2 processes for filing a late response. You can make an application prior to the deadline or after it. They're slightly different procedures, but it can be done. That said, we don't want to be relying on that. You don't want the risk that the tribunal disagrees with you. So as much as it is sometimes tempting to go, the business is really important, I've got to keep going, I've got to keep running, I've got to do my primary job, actually dealing with a claim is not something that wants to be sat on the back burner ever. You know, the last thing, selfishly, to an extent, I want as a lawyer is to be desperately trying to draft a response form 3 days before it has to be filed. Particularly, now not selfishly, as I'll almost certainly have to come back to you with questions, and you know, we don't want to be working between us late nights, early mornings, 15-hour days trying to file a response if we don't have to. That said, it is a critical document. The ET3 is an important piece of paperwork in the tribunal. It's not just your response to the claim, it is your stated position. The ET1 is the claimant's opportunity to say, this is what I think happened factually, and this is what I think the legal claims are. They get limited opportunity to review that. Similarly, once you file the ET3, that is your response to the claim. And it can be very tempting to skim through it and go, that didn't happen, that didn't happen, that didn't happen. And equally, it can be very tempting to write a long narrative. Neither of these are particularly ideal. What it needs to do is be clear what your position is, both on the factual content and on the legal side. So we'll move on from under the technical side of filing a response, I suppose, to what preparing it actually looks like. And again, Nathan will be familiar with this, as will those of you who have dealt with tribunal claims with me or other lawyers before. There are 3 types of claim form you get. There's the professionally drafted one, which will be the one that really makes you panic. There will be the claimant acting for themselves, what I call short version, which may well be a sentence that simply says, I was unfairly dismissed because they sacked me, or words to that effect. Or it may give a couple of lines about things that were allegedly said to them that they say are a form of discrimination. And the 3rd type is the litigant in person, someone acting for themselves, long form one, which in my opinion is the worst of the 3. And that can be the legal equivalent of the 20-page grievance that they filed with you anyway. They may have just copy pasted it. And no doubt you've been on receipt of all 3 of these. Yes.
I have indeed, yeah.
So I suppose when you get that, let's start from maybe your point of view and the HR in-house point first. Okay, the professionally drafted one, fine. Hopefully that will be clear what the factual and the legal issues are, and you can generally fairly easily go through that and go, right, paragraphs 6, 7, 8, and 9 in the background, 10, 11, 12 are saying that we're in breach of section whatever of whatever act. What do we do with the other 2? What's your kind of response when you see maybe the short version one?
The short version, I mean, neither are my preference, to be honest with you. As you pointed, it was a really good comment, actually. The professionally drafted one can be the one that feels most intimidating to read, but actually the most straightforward and logical one to interpret. So that is easy, and I've always preferred to have that one and know what I'm up against. The short version is, it can be very, well, there's 2 approaches. So you can either view it as this is easy to deal with because actually it's short and there's not much to the claim. But actually, in my experience, that isn't actually always the case, because what I worry about is what are they not telling us, what they not included in that claim form that they may later include when they consult a legal advisor. Then the other issue I have with the long form version is that often that can be very difficult to pull out all the relevant complaints that need to be responded to and dealt with. And so that can take even more time. It's a bit like, I'm sure most of you on the call will have received, a 10-page grievance letter, and you'll go through that, go, actually, what's relevant here? What do we need to address? And what is just kind of background noise where someone is venting and offloading? So the long form version is more troubling to me, because I think actually I'm not always clear on what is the most relevant aspects of that complaint, which is why great legal advice is always handy, because we can sit and go through that together. And
what actually matters.
and pick it apart. So that's really helpful.
And I mean, ultimately, that is what the EC3 should do. That's what the response is for. A well-drafted claim form will, as I kind of said, go, here are the factual points that happened. Here are the factual points of dispute where I say something happened differently to what I know the company is going to say. And here's my breakdown of why I think that's an unfair dismissal, why I think that's a form of sex, race, disability discrimination, for example, and break down the tests quite neatly. That's obviously how a lawyer will always draft it. Yes, I agree with you that the short version one, I think probably the short version one is, as you say, that temptation to just almost write a sentence that's just, well, this is denied, we can't respond to this. The problem with that is the short version of a claim form, you're going to have a case management hearing at some point, and the judge, if the individual is still self-representing, is going to sit there and say, Mr. Mrs. whatever Smith, what actually are you disputing here? You know, you've ticked unfair dismissal, you've ticked sex discrimination, you've explained you were dismissed, why do you think that was unfair? Then that all gets teased out. They maybe get another response or opportunity to write out what they think has happened in more detail. You then inevitably are going to ask for a further opportunity. You might as well have done it at stage one. You might as well tell your version of events straight away and say, well, actually, this is what we think happened. We think we've responded adequately to the claim. Let's not give the claimants an opportunity to say, well, we don't need to. We've defended our claim. I'm not saying it'll always play out like that, but the flexibility of the tribunal system means that both parties are going to get an opportunity to readdress this either way, but that comes with cost and time commitments. And as you say, similarly, the long version one, yes, everything might be in there. It might be in there in a very garbled way, but hopefully it'll be in there and can be teased out. Again, that's the benefit of getting it to an advisor, whether that's in-house or externally, very quickly, and somebody be able to say, right, yes, we've got a 10, 15-page document here, but there's actually only 3 legal issues, and here they are. We can ignore everything else and just get that put in a response somehow. And yes, you do respond to everything, even if it's just a denial, even if it's just to say, we don't believe this is a legal claim, or we don't believe the tribunal has jurisdiction to hear this. I've mentioned on these sessions before, you'll commonly hear an employee talk about data protection breaches. Well, okay, that might lead to a constructive dismissal, it might be a form of discrimination, but a data breach is not a claim that the employment tribunal's got jurisdiction to decide on in isolation. They can't award for a data protection breach. But you still want to respond to it. You still want to say that. Because what you don't want is the employee turning around 6 months through the process and going, oh no, I'm alleging it was a form of harassment. We want to know that early on. Okay, so that's kind of steps and process and procedure. And in a sense, it will be going through the entire process that you've already done internally again, but with a different lens, I suppose, is the sensible way to look at this. So I will touch briefly on a couple of other procedural and structural points before we move on to final hearing. We'll have a good chat, hopefully, about being witnesses and what final hearing is like towards the end. I want to touch on one very rare element of a response, but they do crop up occasionally, and that is employer counter-contract claims. They can be raised in the employment tribunal, but only where the employee has already brought a specific breach of contract claim. So if the employee has only brought a discrimination claim, you cannot in your EC3 defend the discrimination claim and say, oh, by the way, they also owe us £5,000 because of this breach of contract. So the employee has to raise the breach of contract first in order for you to counter it. The most common breach of contract claim, of course, contractual notice pay not being paid properly. So in that situation, there is a breach of contract claim pleaded. If you believe they owe you money for some reason, you can then assert your counterclaim. So that might be overpayments of salary, of holiday, bonuses they weren't entitled to. If they have themselves maybe resigned in breach of contract, so you may well find that the counter argument is it's a constructive dismissal and breach of contract, says the claimant. I resigned without notice. I'm entitled to do that under a constructive dismissal, and I'm entitled to pursue what my full notice should have been. Your counter argument may well be, well, okay, but your notice period was 3 months. We've had to engage somebody to cover your work during that period, and it's cost us X hundred, X thousand pounds. You may decide to pursue that. That said, you will want to decide whether you want to do this based on a couple of things: the value, the likelihood of you actually being successful in it. If it's a high value contract claim, of course, this counts for both employees and employers. You may want to bring separate civil proceedings rather than the employment tribunal. The employment tribunal is capped in its contract claim powers to £25,000. So you will sometimes find that there are two separate proceedings that arise where there's a high value breach of contract claim, perhaps over shares, or a high salaried individual who's got a long notice period. It can sometimes be worth pursuing these separately. The employee does then have an opportunity to reply separately to the EC1, EC3 process. So what happens there is they file the EC1 with a contract claim, you file your EC3 annexing a counterclaim application. That is sent to the employee, who then gets to say, actually, these are the reasons I object to the counterclaim. It's the only time you get sort of that backwards and forwards written litigation in the tribunal officially. As I say, they are quite rare. They don't arise very often. Counterclaims against, I think any contract claim against an employee is unusual and often not high value. I can only think of some 2 or 3 in the last 5 years that I've even considered.
Yeah, well, I would say I've probably done in the last 10.
Yeah. Fine. So, general process for the employment tribunal then, now that we're getting on to procedure a bit more. Early conciliation, the pre-claim stages. See what happens there, see if we can resolve. If we don't think we're going to resolve, make use of the ACAS period to get as much information as you can about what the claimant thinks has happened and what they want. Starting a claim, that's the ET1 form, that goes through that process. Who knows when it will be issued? Who knows when the tribunal will get a chance to look at it? And eventually it will land on somebody's desk. File the response within a month and or application to extend that time as required. And then ultimately, we're going to start moving into things where the tribunal will take a bit of control. So we will probably have a case management preliminary hearing initially. That could well be simple case management. What is the conduct of the case going to look like moving forwards? It could be a preliminary hearing, what we would call a substantive preliminary hearing, to deal with a major issue, such as whether the tribunal even has jurisdiction to hear the claim. Or there may be a dedicated preliminary hearing if, for example, the question of disability is in dispute. You may well find there's an entire day just to deal with that one issue. Naturally, of course, once all of that is resolved, assuming the parties haven't settled, or the case management things have been dealt with, we've gone through disclosure, we've done witness statements, we eventually get to final hearing, and then, of course, decision and remedy. So, let's talk about case management hearings and directions in a little bit more detail. As I said earlier, the Employment Tribunal has fairly wide and fairly flexible powers to manage a case in the way that they see most fit. There's the overarching powers that come from the regulations. There's national presidential guidance that is issued, and there is also separate regional guidance for case management. So how tribunals approach general case management issues may vary depending on which tribunal you're in. So as an example, I know that the Central London Tribunal quite likes sending out a timetable at the same time as the notice of claim. I think it's a relatively straightforward case. I've had it happen on one fairly recently. I was acting for the claimant in that case, so we obviously got a copy of the notice of claim once it had gone to the respondent, and the tribunal had issued document disclosure deadline, witness statement exchange date, and the final hearing before any of us had even actually known it had been dealt with, to be honest. So that does happen. We are slightly different in our region down here. What Southampton tend to do, and the regional employment judge in this area is a massive fan of case management preliminary hearings. So what we tend to do is once that claim has been sent to the respondent, at the same time you'll probably be notified of the first case management hearing. So what will happen in that case management hearing? It's usually a phone call. It can be done by video. The parties will be asked to produce an agenda, a summary of the case and their proposed timetabling in advance. And what those case management hearings generally are primarily administrative. They're all about what are the issues in this case, what actually needs to be decided if this goes to final hearing, and assuming it's going to final hearing, what does that process look like? So between discussion, usually between the various representatives or parties, if they're not represented, and the judge, that is often done in an hour or so. We'll usually address what are the legal issues here, what are the factual issues, and are there other things we need to discuss? Do we need to have a separate hearing because disability is in dispute? If disability is in dispute, the tribunal may order the claimant to produce additional evidence, to produce an impact statement, and then for the respondent to have an opportunity to change its position, to accept or continue to dispute the fact of disability. If it is still disputed, as I say, there may well be a full-day substantive preliminary hearing just to deal with the issue of disability. And of course, if disability is not established, the majority of claims may well be struck out at that point. The tribunal will then also deal with things like exchange of documents and disclosure, production of the bundle, and producing and exchanging witness statements in advance of the final hearing. So on the subject of documents and disclosure, probably to an extent the bit we all dread most, disclosure of documents, I think, and compiling bundles and paperwork. The important point with disclosure is it is a very high obligation and it is an absolute obligation. That obligation is all relevant documents, whether they help or hinder your case, which are in any way in your possession or control. Documents means almost anything. It is not just paper documents, it's electronic copies, it's text exchanges, it's video, it's CCTV footage, it's records, it's handwritten notes. In short, it is anything other than something that is subject to one of the two forms of privilege. And before I come on to privilege, let's just have a chat about the kind of process of going through this. If there's been an internal procedure, to an extent, an element of this is quite easy. It's the disciplinary pack, it's the bundle, it's the outcome letter, it's all of the evidence that you've already used. But of course, the obligation is higher than that.
Yeah.
And I suppose your process of that, I'm going to say to you, I need everything that might conceivably be relevant.
Yes.
What's your next step internally? What does that look like?
Well, the process we, from an HR perspective, is doing that data search, really, looking for those contemporaneous records, meeting with your management team, so line managers or supervisors, asking them if they have any relevant handwritten notes, as an example, or documentation that they kept themselves. Often, a great place to start with is looking on an individual's desktop to see if they've got anything that's been casually saved there. For them to later refer to. So you've got to be really creative in terms of how you identify where you're going to look, because actually it'd be very easy to overlook locations where information could be kept. There are tools, software that you could use to help with the data, if you're doing like a data search of your systems. So they can be helpful depending on the volume of information that you're looking for. But essentially, it's taking the time to go through in a methodical way the process of identifying what information you have and then making it available. I mean, one of the things I learned earlier in my career was to document the process that I followed. Yeah. So if anyone said to me, "Excuse me, Mr. HR Manager, talk to me through the process you went through to obtain and identify relevant information," I was able to go, actually, on this date, I did X, Y, and Z, and this is the return from that process. So at least if something did later on become available, information I didn't have or wasn't able to gather, I could still rely that I went through a reasonable, fair process. It was, I was honest. I managed the integrity of that process, maintained that. So for me, going through that process, it is time consuming. Depending on the matter, if it's particularly complicated, you have to just accept that you're going to spend, a large amount of time going through that process, but it is worth it later on. Because actually, if you give your legal advisor all the information that you have, it sets you up, for success later on, doesn't it, through the process? So it is definitely a time-consuming process, but one that is particularly important. I've seen various standards of that process. I've also seen people attempt to hide information and destroy evidence. That's not something I have ever done. It's certainly not something I would ever advise. If there's information that suggests that I've not got something right procedurally, I'd rather stand by that and deal with that later on and hold my hands up than actually be found to be trying to hide information, which damages, my professional standing and my integrity.
And not to mention it's a criminal offence.
Absolutely.
It's contempt of court to be destroying evidence.
Yeah.
And you make a perfectly valid point. Do this early and do it quick, because anything that is going to hinder the case is something we want to be able to address. Yes, it becomes disclosable, but can we find a way of mitigating the damage that it causes? One of the worst places to be as a legal representative, in particular, is in tribunal, where somebody turns up on the morning, they we found this extra document where it says from the MD, just sack this person, I don't care about them. The last thing we want is that turning up and then not knowing how to deal with it on the day. Much rather have that 6 months earlier. So it is, as I say, a very high obligation duty. It is quite an onerous one, and to some extent, arguably more onerous than a subject access request. You know, at least in that situation, all you're doing is looking for an individual's identifiable information. Yeah. In this case, you're looking for anything at all whatsoever that may help or hinder the case. It may not have the employee's identifiable information on it. Yeah. It may well not identify the employee. But it could be some background document from 6, 8, 10, 4 years earlier that is somehow relevant to the case. As I say, yes, and I mentioned it earlier, documents do appear on the day suddenly. Cynically, that's sometimes tactical. It shouldn't be, but there is an ongoing duty beyond the set date. If you do discover documents after the date of disclosure, it's not as if your duty stops on that day. The tribunal take the view of that is relevant, we would love to see it, is pretty much their approach. So if things do appear on the day, it's often a case of so be it. I mentioned earlier that it's any document in your possession or control. So yes, okay, that is the document you've got saved on your system, the physical stuff that you've got in your office. It is also, for example, anything that you may have sent to a third party, but which you have control over. So if you are using an external HR provider, it is any document you've sent them, even if it's no longer technically, quotes, in your possession. I'll come on to privilege very quickly in a moment, but it does also cover, for example, documents you may have left with your lawyer, unless they are subject to privilege. So 2 forms of legal privilege. I'm not going to do a dedicated session on privilege because I could talk for hours on when privilege does not apply. But the 2 major forms of it, legal advice privilege. So that is specifically in relation to a piece of advice between the lawyer and their client. We call it legal advice privilege in the UK. I actually prefer the US client attorney privilege, definitely, because I think it's clearer. It is advice that is obtained by the client. Therefore, if my client is an organisation, it's the advice I'm giving to the business, not necessarily the advice I'm giving to an individual. And that's an important thing to remember. And it doesn't always cover advice which I've given to the business, which is then passed on or shared. That's an important thing to bear in mind as well. That does literally just apply between a client and their lawyer. Nobody else can claim that privilege. There's not some magic accountant's advice privilege or anything like that that also exists, unless the advice also somehow qualifies as legal advice. The other form that is more broad is litigation privilege, and this is one where, not being legal advisors, HR in particular are able to rely on a little bit more. It's a harder one to prove, but it does kick in once litigation is in contemplation of the parties. So discussions you're having with your external HR advisor, certainly after a claim has been issued, are likely to be under litigation privilege. Or I would suggest at any point after an employee has said, I'm going to take you to court for this. I think that's the most obvious point at which litigation is contemplated. And it is an important distinction. There's a difference between what a client can say to you and what they can say to me. And you know, that's not disparaging the HR profession. That's simply a legal truth.
Yeah. And it's a really important one, actually. And I certainly, from when I was running my own consulting firm, even now with the work that I do through Threatons, it's something we manage very carefully with clients. We make clients, fully aware that conversations between me and the client, that they should consider that's potentially disclosable. Almost in all cases, it's going to be, unless, as Chris has just pointed out, they're asking for my advice, and we anticipate that litigation is going to be imminent, then yes, we might be able to rely on litigation privilege. That being said, I'm always really cautious, and I don't just automatically rely on litigation privilege. So I always say to my clients, and I would say the same should apply when you're handling matters as an in-house practitioner. Everything you're communicating about regarding an employee with your line management team, you should consider that as disclosable, and therefore you should be considered in terms of what you're putting in writing, and indeed what you're saying to somebody in person or in front of others, because that could come back later on. And I've seen that happen in practice, where somebody will say, well, actually, I remember that you said X, Y, and Z, and then you've got to stand by what actually took place. So yeah, it's a really important one to manage.
Yeah.
So it's something I'm very aware of my
Absolutely.
practice.
And going back to the slightly tongue-in-cheek example I gave earlier, the MD saying just sack this person regardless, we don't care. If you're after advice on the safety and security of that, that's a conversation you could have with me, but not with an HR advisor. That is, I think, an important distinction to highlight. It is also worth pointing out that legal advice privilege doesn't attach to the lawyer, it attaches to the client. So just having a lawyer in a room does not make the entire conversation legal advice privilege. This has been relied on in various courts and tribunals before, where people have said that board meetings are legally privileged under legal advice because a board member is a lawyer. It only applies to the legal advice that is being given in the capacity of lawyer to clients. An extension of that, confidential, business sensitive, or commercial information is not the same as privileged. There may be other reasons why you don't disclose it, i.e. it's not relevant to the issues in dispute. That is a completely separate argument. But yeah, a confidential document is not the same as it being privileged in any way, shape or form. So it is always worth considering that part of the impact of tribunal, particularly for a respondent, is that commercially sensitive information may make its way into court whether you want it to or not. Right, we've done that. We've gone through that process. I'm not going to do any talk on witness statements today because partially that's exceptionally dull, but if people are genuinely interested in it, we can absolutely do a session where we talk about what witness statements look like, what should and shouldn't be in there. But you probably get a lot more from that from a practical experience of it. So those of you who are coming to the mock tribunal next month will see probably some deliberately terrible witness statements and why they shouldn't look like they do. So we'll skip straight forward to final hearings, what they look like, because also with the advantage of having Nathan here, I do want an opportunity to talk about being a witness in some detail. So, final hearings in the employment tribunal. Yes, as I've said throughout today, they are less formal jurisdictions, but they are still a court. And I think people, particularly certain claimants acting for themselves, sometimes forget this. So you're not going to have people, certainly the judges are not going to be sat there in gowns and wigs, and nor are the barristers if they turn up, or solicitors are entitled to wear them occasionally. You will find everybody is in business attire. Obviously, the timetable will already have been set. So at some point in a preliminary hearing, there'll be a debate about how long the final hearing needs to be. A straightforward unfair dismissal or breach contract claim, 1 or 2 days. Average discrimination claim, 4, 5, maybe 6, which rolls over a week to allow for remedy as well. But it is perfectly conceivable for a tribunal claim to be complex enough to have enough witnesses involved that it runs for 10, 14, 20 days. I'm thinking the longest I've known, I think it was 3 weeks.
Really?
Yeah.
No, about 7 days, I think it was for me.
Yeah, it's not one I was personally involved in, thank goodness. Yeah. You may find, depending on the nature of the claim and how it's structured, that it is a lone judge sat hearing the case. Traditionally, non-discrimination claims were heard by a lone judge. Any discrimination claim or sometimes whistleblowing claims have 2 lay panel members as well. That is shifting slightly, partly for cost saving, partly for listening issues. Lone judges can hear all claims if the parties agree now. The panel members, when they are there, they are not legally trained in sort of the sense of being lawyers. And traditionally they were there for balance purposes. So you would have sort of someone who was in principle pro-employee, maybe a former trade union official who is now being asked to sit as a panel member, and a traditionally pro-employer person, perhaps somebody from a sector or organisation or representative body. Almost all judges are or have been practicing barristers at some point. There are a few who were also solicitors. No comment on the difference between us. It's just simply that it's more natural for barristers who are in court all day to become judges. 2 types of judge really in the employment tribunal, the sort of permanent ones who are there all the time who've given up practice, and the fee paid ones who are also active practicing barristers. The advantage of this generally is most of them are about as up to date on the law as you can possibly get, because most of them are doing it as well at the same time. Worth remembering that unlike many other jurisdictions, the employment tribunal is an open court. So you may well have observers rock up. I've had it happen. Law students who are just interested, trainees who just want to see what an employment tribunal looks like. Unusually, certainly compared to almost every other jurisdiction, any other witness can sit in the back of the tribunal room and watch what's being said about them, which is something we'll come back to next month, potentially. And of course, you can even have the press in attendance if it is a high profile enough case. This is true of both in-person events and online hearings. Equally, of course, this means if you're interested, you can actually just contact your local tribunal office and ask if there's an interesting case you can sit in if you really want to. It does happen quite regularly. Witness statements taken as read, so there's no kind of reading of your evidence as such. You will move straight to cross-examination, which we'll come on to very quickly in a moment. The tribunal panel also have the power, ability, and regularly exercise it to clarify points by talking to the witnesses themselves. And it is worth considering that a large number of hearings in one way or another are increasingly being done remote by the video platform or hybrid, where some people will be in the room and some people, particularly certain witnesses, may be dialing in remotely. So there will be procedural points to consider with that as well and the practice of that. But those are all quite technical, and I think we only address them on a case-by-case basis. I'm conscious that we're just about to hit 11 o'clock, so those of you who were expecting this to just be the hour, I won't be offended if you need to go because you've got other things tied up. So if you do need to go, thank you for joining us. We're going to carry on with a quick chat about being a witness, and then we'll also hang around for a little while to take questions as well afterwards for anybody who is still around after that. Those of you who need to go now, the next session will be the final session in the Employment Tribunals series. Wednesday, the 4th of June, we'll both be doing it again. We'll look at outcomes, enforcement of judgment, the appeals process, and also what happens internally after you've finished a case and what that reflection and learning looks like. So anybody who does need to go, thank you for joining. We will carry on. So, final hearing and being a witness. I have never been a witness in the Employment Tribunal, so this is going to be difficult for me to comment on. I've had the fun, of course, of being in tribunal as a representative. It's a very, very different experience. People become litigators because, in a sense, we're sadistic and enjoy that process. Nathan, however, you've been a witness in the Employment Tribunal. The process and doing the statement and swearing in and all of that side, but actually that is all very technical, very legal, not very exciting. I think what's probably more useful to a room of 20, 30, whatever people are up to at the moment who may become witnesses. What's it like?
It is. I've been doing this work for about 20 years, so I was given evidence probably a handful of times in those 20 years in the Employment Tribunal. First time obviously was very nerve-wracking because I was in my first HR manager position, so you had everything that went with that. Did I do the right thing? Because I was involved in writing the process, and that's how I ended up becoming obviously a witness. So you have the whole kind of emotional aspect of, have I got it right in the first place? Have I let the business down? Second guessing yourself. So that all plays a part on the build-up. Obviously, preparing a witness statement and working with at the time it was the law firm that we were using who were responsible for taking witness statements. That was fairly straightforward, that process of putting everything together into a witness statement and agreeing that. But then obviously there was a time here between witness statements being prepared and getting to the actual hearing. And so as we had the date, we knew that was coming up, and as we got closer, the realization started to kick in. Okay, I've got to give evidence, and I think on the day, it really does kind of hit you that you're there. I know you'll talk probably a little bit more about the process of being either sworn in or affirming before you give your evidence. So that really then hits home kind of the importance and the seriousness of the particular process that you find yourself being party to. For me, I think the one thing I would say to anybody who's facing giving evidence in an employment tribunal is absolutely taking the time to prepare yourself closer to the hearing date, because there's no point doing it months in advance. But the advice I was given, it was great advice from the lawyer, which was, try and read your statement at least 3 or 4 times before you get to the day. If you can read it, the night before and perhaps on the day, if you have time. You don't always have time. If you can, that could be really helpful, or not, because as we were talking about earlier, sometimes that can make you too focused on what was actually written rather than just actually relaying, what took place more naturally. For me, I'm quite a detail-focused person, so I found it quite helpful to read through my witness statement the evening before and just refreshing myself essentially, because there was a period of time between, when matters occurred and when the hearing was taking place. And then really going in with, the viewpoint, I'm going to be honest, I'm going to be open and honest about what took place, and not really deviating from what was in your witness statement, which is easier said than done, because when you get to cross-examination, that is a whole other level of stress and anxiety. But I mean, I survived, but anyway, I think you can ask.
Yeah, well, no, I wasn't actually. I was kind of going to carry on where you are, because it sort of boils down some of the points I was going to make. I think some of the informality of the employment tribunal can encourage people to think it's not the same as giving, criminal evidence, or even in the High Courts. You are still bound to tell the truth, the whole truth, and nothing but the truth. That is the oath, or the non-religious affirmation that you will give. Yes, of course, we know that there are going to be two completely conflicting versions of events, and therefore it could well be said that somebody is lying. I think that probably stretches the definition a little bit, because we're often talking about interpretation, intent, the way somebody has understood what was said or written or communicated. I do think that's a big difference from kind of the perjury level of lying, which can sometimes come across as. And the tribunals are attuned to that. But I think you're absolutely right. It's preparation. The employment tribunal, as we've said many, many times on these calls, it could well be that your final hearing is 2 years after the things that you're trying to remember happened. That is part of the reason as well that things are front loaded, and we try to get witness statements done early. I would always suggest, frankly, months before witness statements are due, the moment you know what the claim is, jotting down what you remember.
Absolutely.
Do a diary at that point. That's going to then form the basis of your statement. The prep for the hearing itself is absolutely know the case, know what evidence you are giving, and understand what that evidence is for. And that is where good engagement with your lawyer is going to make all the difference. This isn't just, this is what we need you to say.
No.
It's, these are the reasons that we're trying to say what you're saying and how we're trying to frame what you're saying. It's, in a sense, it's very similar advice to what I would give a claimant, which, of course, fortunately, you presumably not had to do very often. No. There are people who know this case better than anybody. The claimant knows this. They've lived it. They are going to be ready. And they are going to be ready to explain their version of events in minute detail, and they are going to be absolutely adamant that they were right. You have continued to work. You have had thousands of other things, hundreds of other days at work since then, dealing with different matters. And that is where that importance in knowing what you're saying, what you're intending to say really comes from. And the job of the claimant's lawyer, of course, is to make you look like a liar, the worst boss ever, the most terrible employer there could possibly be. And that cross-examination tactic will generally be, here's what my client says, you agree with me, don't you? Because it's a classic cross-examination question, is to, and we're allowed to do it. When we're cross-examining somebody, we are allowed to ask leading questions. It'd be things like, let's imagine the investigation report, the disciplinary hearing. Turn to page 17. That's the disciplinary outcome letter, isn't it? We've got to say yes, of course it is. It's signed and dated by line manager, isn't it? Yes, it is. It was written by you, wasn't it? You've got two choices here. You can be honest, and it probably was, or you can say no and carry the risk that there's some metadata somewhere in the pack. And it is an important point. Absolutely,
such an important point.
And it is the job of any cross-examination to identify the flaws. And that is ultimately what cross-examination boils down to. It's a fine skill, and it's an incredibly difficult one to resist when you're there in what for you is an unusual and stressful situation. The lawyer is used, the barrister particularly is used to it.
I think for me, just drawing on my own experiences, is going in and it's not always easy to do, and it's a skill that I've learned over the last 20 years, which is remove the emotion. Go in, focus on facts, absolutely. As Chris just said, I would never lie. So if someone said to me, did you draft that letter? If I draft the letter, I'm going to say yes. And actually that speaks to, and that's probably a whole other session on actually the process you follow and how clinical you are in terms of administering processes. But in terms of giving evidence, absolutely, it is removing the emotion from it, because if you don't, that's going to show up in the way you give evidence. And when you are under cross-examination, in particular, and when you're being pushed by a barrister who's going to ask some really probing questions in a particular way, it's going to make you feel like you need to be quite defensive of your own position. It clouds the quality of the evidence you give, doesn't it?
Absolutely.
And actually, you can almost spiral and end up in this situation where you're almost tripping up over your own evidence.
Yeah, because you're now saying, you felt inclined to agree with the barrister. And the barrister will do this. This is why they put on posh accents. This is why they hold themselves in a certain way. They're making you feel as though they have to be right in what this. I'm the lawyer, I'm the barrister, I must be correct here. And it is a skill, particularly with somebody like that, to be able to say, well, actually, no, that's not what happened. And sometimes that's what you need to do. Pause.
Yes.
The importance of pausing and thinking about it. If they've asked you to look at a page, you may be absolutely familiar with it. You may be able to recite it by heart. But turn to it and read it. That's going to give you 30 seconds to a minute to think about your response anyway. And there's all sorts of these skills and tips that, as lawyers, we're not allowed to guide you through giving your evidence. We're not allowed to talk to you once you're giving it about the case in any way, shape or form. But these sort of general tips are all things that play into part of the advice, and which, if you're not receiving ahead of a hearing, you should be asking about. What is it like giving evidence? What should and shouldn't I be saying? How should and shouldn't I conduct myself?
I mean, that's a great point actually you raised. I mean, certainly when I was for an ER help desk, where we did, most of my grad focus on ER case management. So you stay with very complicated situations and working with lawyers to resolve disputes, etc. One of the things we did, obviously, while we wouldn't allow ourselves to be in a position where we seem to be kind of prepping witnesses or advising what they should or shouldn't say, one of the things we did was create a checklist of what it's like to give evidence in a tribunal, and it was just a generic document that you could share with somebody, just to give them a framework. Okay, this is what I'm likely to face, and to give them a framework of how they should go about preparing for that. And as Chris said, on the day, the one thing I learned from my earlier experiences is don't allow yourself to be pressured or hurried in responding. Take the time. Don't feel the need. You have to, allow there to be a silence while you either are reading a document or gathering your thoughts. Because what you want to do is make sure that whatever you're sharing at that hearing is informed, is considered, and it is factually correct. So that's an important point.
And I mean, the thing I often say to witnesses on both sides, and it's sort of the final bit of advice I tend to give: your job is to help the judge make a decision. And what I often say, and I don't know if you maybe experienced this in practice, is it's a really weird situation to find yourself in. The barrister is going to be over there asking you a question. One of the best ways to try and calm yourself down actually is to turn and answer that question to the judge, who is the person who actually wants that information. The barrister knows what they're expecting you to say. The barrister's got an answer they want. The judge doesn't. The judge wants your evidence, and that is your primary job as a witness. To go in and help the judge understand what happened here, and hopefully find in your favour.
Just such a good point. This goes back to some training I had when I was trained to be an investigator. And one of the tips we were given by a barrister was to pick out someone who you consider to be neutral, and that would be the employment judge.
The judge, one of the lay members.
And then you can address your answers.
Seems to be in your favour.
Absolutely. But it's really helpful in that way, because what you're able to do is not focus on the barrister who's cross-examining you, because that can be fairly intimidating, but actually be focused on someone who you perceive to be relatively neutral. Just helps you calm, helps you remain considered. You can take the time you need to give your response and your answer without having those nerves take over.
Absolutely. Right, that's coming up to an hour of us actually talking now, so I don't want to keep people any longer than we need to today. We will hang around for a couple of minutes if people have got any sort of general questions they do want to ask about the content from today. Just very quickly to repeat what I said a moment ago, and then I'll start coming into questions. Next session will be we'll be looking at tribunal outcomes, what happens next. So all the various possible outcomes. We'll talk through maybe how awards are looked at a little bit, how those judgments can be enforced. I'll touch briefly on the appeals process, although hopefully you'll be in a position where you don't have to do that. I'll touch briefly on costs in the tribunal as well, and again, Nathan will join me. We'll talk about the reflection and learning, what happens back in-house, whether a case is successful or not. And as always, when we're talking about things like that, we'll get an opportunity, I think, to look at some of the mitigation steps that could then be taken, presumably as a result of that. Those of you who do need to head off, thank you very much for being patient with us today. We've got a couple of questions that have come in, so we will look at those briefly now. But otherwise, those of you who need to go, thank you very much for joining us. Have a good rest of your day, and we'll see you in June.
Thank you.